It's humid.
All right, so Norma just received a text. Tom said he left the house at 7:42 a.m. He's still on I-10 or wherever, so we'll be waiting a little bit, so that's fine. I always tell people you're meant to be here, you know, at 9, but if there's traffic, what can you do? It was a sad weekend. Well, it's sad for Cornelius. Florida lost.
Oh, yeah, it did. It did.
LSU lost.
I heard that was like a nail biter.
You know what? It shouldn't have been a nail biter. There were some mistakes that were made in the game, which resulted in flags.
Well, I wanted LSU to win because I have a cousin that's a USC alum and we're big rivals, so.
But I did get a chance to watch some of the Paralympics. I love watching the Paralympics. But LaShawn, I discovered something that's sort of a solvent green situation. Did you ever see solvent green?
I have.
Yeah. It's the people. Okay, that's the key word.
Okay.
So then I was watching, and guess what? Somebody has this theory. It's a child. SpongeBob SquarePants, the Krabby Patties.
Oh, yeah, I saw that.
That's a solvent green situation. Like, where are all the crabs?
The 70s, right? That movie?
Was Charlton Heston in that?
Yes, he
He
was.
was really young.
Yeah.
Really young.
It's the people.
It was, if I remember right, it was mostly taking place at a development underground, right? Because the
Yes.
surface was.
Contaminated.
Yes.
Mhm. But you know, Wolves got bad reviews at Venice, but I'm still gonna go see it. I do my own reviews. Hello. They tell me it's pouring.
Have the voice. Some scratch. Strange. So none of those things. Yesterday.
Hello.
Thank you.
You're welcome. So I see you're not wet. Everybody else is who came.
Had a raincoat.
See, prepared. Oh, no problem. Everybody's running late because of the weather.
I didn't know that. Oh.
Morning, Your Honor.
Good morning.
Morning, gentlemen. Oh, 7:42.
Yes.
I don't know if it showed up through the
All right.
clerk's office, but it was this week.
Thank you.
Got mine? Sure. Thank you. 7-year-old that gets dropped off to school, like Jane, we just like would feel like we couldn't start heading south till we dropped him first in the line. To get him to school. Like, maybe.
His parents usually.
And everyone, just let me know when you're ready.
Terribly concerned that I was going to be late, but quite frankly, I considered it relatively inviting the fact that I got things in everything.
Yeah.
Oh, sure.
Judge, I believe the parties are ready when you are.
Okay. Just let me know when you're ready. All right. Court is calling 2023 CR 11510A, State versus Alfred Flores III. 2023 CR 11510B, State versus Eleazar Alejandro. 2023 CR 1510C, State versus Nathaniel Villalobos. Could I have the parties announced for the state?
Jeff Mulliner, David Lunan, and Daryl Harris for the state.
For the defense?
Tom Nisbet on behalf of Alfred Flores.
All right, and your clients are, oh, I'm sorry, Mr. Cifuentes.
And Sequentis for Eleazar Alejandro, and he's present.
All right, thank you.
And Patrick Valentine for Nathaniel Villalobos.
All right, thank you. All right. All right, so first things first. I'm noting some documents that have been filed under Villalobos case, and I don't know if the defense counsel intended to file it. One is the notice of joint defense agreement. Was that intended?
Well, I filed a notice of the joint defense agreement. I did not file the agreement itself.
Okay. All right. All right, so State, have you filed any motions for continuance, another motion for continuance or no?
Not a subsequent motion, Your Honor.
All right, then defense, I'll hear your motion for continuance. Just remember, whichever client you're speaking for, please make your announcement as their attorney so that the record can be clear on which attorney is speaking, and you all may proceed in whichever order you wish to proceed on.
And Sequentis for Eleazar Alejandro.
Oh, and counsel, everyone can remain seated. It makes it easier for the court reporter to hear. I don't take it as a sign of disrespect. You may proceed.
Your Honor, there was information that I did not put in my prior continuance. I'm not going to cry about 5 circumstances, but they were important events that happened that impaired my ability to be ready during this period. I was hospitalized on May 21st through Saturday. And I spent 2 weeks convalescing afterwards. And in conjunction with that, on July 23rd, I had a medical procedure and I spent a week convalescing after that. Also, my mother passed at the end of June, and a few weeks before that and a few weeks afterwards, I was attending to her passing. And so I was unable to devote attention to issues that are the basis of my continuance. Now, what I'd like to make clear is that in the attachments that we sent, we asked for the software to play the videos that were produced as part of discovery. And I asked for the software and the audit trails. Admittedly, the state eventually performed, not performed, but provided the audit trails. But those audit trails are incomplete. And apparently, no one in the state seems to understand that the software is cloud-based. And no one seems to understand for the state that the evidence that's cloud-based contains bookmarks, comments, and they are kept in evidence.com. And they did produce PDFs in June of this year. And if I may approach the court,
Yes.
one of the PDFs they provided has a URL here. And that URL contains data. But the state did not provide us the data contained in that URL. And so the court can understand evidence.com, all use of force cases are reviewed by sergeants as required by SAPD policy. And I can represent to the court that I have been to SAPD IA, Park Police IA, and Airport Police IA. And they show officers the videos on evidence.com, and also on evidence.com, the bookmarks will show when the IA sergeant or investigator reviewed the embedded timestamp. And not only did they view the embedded timestamp, but they're required by their general manual policy, if I can approach.
Yes.
They're required by their general manual policy, procedure 410. And I'd ask the court to take judicial notice of this policy, and it's available online. And I think under the rules of evidence 201D, the court being provided with that information can take judicial notice of this policy. And
And I'm sorry, if you'll not turn your back to the court
I'm
reporter,
sorry.
it makes it difficult to hear.
I'll go sit down.
All right.
So on 410.14C, which is the second from the last page, personnel reviewing DME shall manually document and the purpose of their viewing in the notes field in the EWC application. And what that means is they're supposed to keyboard in evidence.com when they review the digital media and the body worn camera, their comments. So whether it's an IA investigator or a criminal investigator, they're required by their own policy to document their comments. Now, in this case, it's critical because What's clear from the prosecution guide is Detective Soto, and also clear from their defense expert, is they make no reference to about 21 minutes in time, which would establish the totality of the circumstances that would provide a defense to our clients. So the question becomes, did Soto lie by omission in his arrest warrant for these officers? If there were material omissions, because either he looked at the body worn camera and didn't document it in his prosecution guide and omitted exculpatory evidence, or worse yet, he was wholly incompetent and did not review the body worn cameras prior to obtaining arrest warrants. Now, I believe we make it amply clear that we sought the digital media early on. We sought the software early on. I admit that we were provided some of the evidence in June, but not all of the evidence. Regardless, I would hope the court understand that when we began transcribing the videos in November, we were hustling as best as humanly possible to do what evidence.com should have done for us. And what evidence.com can do is it can actually, and people don't realize this, it can actually transcribe the videos if you use the software, and it can actually synchronize the videos if you use the software. But because we weren't provided the software, we had to hire an expert to do it, and he still has not completed it. There are 3 iterations of synchronization that we're seeking. We've only done 2. We need a 3rd, and we believe that it's essential to our case. And I believe we've used extreme diligence. I apologize that in May and in July, in June and July, that my attention was diverted from this case. I know it's a serious matter for this court, but I just simply couldn't do it. And I tried my best remotely to address these issues by email with the state. And one of the things that the court mentioned last time around was whether we had subpoenaed laboratory. And we cite cases in there, and those cases state that hold the proposition that if you retain an expert, that it's not necessary to issue a subpoena to illustrate diligence, that you can rely upon your contract with the expert. And we have paid our expert 2 significant sums of money, and to complete the 3rd iteration, we need to pump up some more, but we can do that presently. And our expert will be available in the near future, and there won't be an unnecessary delay. We believe we can, in the reasonable time, if the court allows us to confer with the state, and the court propose dates when all of the experts can be available. So we would ask you to grant the continuance. Thank you.
All right. So you had told me earlier about your mom's passing, and I'm very sorry to hear of that. So with regards to the software, is that software proprietary or not? Yes.
That, again, when relaying counsel's request for the Axon codec software, I was told, go get it to the Axon website. I relayed that instruction back to Mr. Fuentes verbally.
When was that? What's the date?
On or about the February or March, June's trial setting, Judge.
All right. Thank you.
If I may respond, sure.
Yes.
In order to access evidence.com, you have to be assigned an account and a login, your username and a password. And the data belongs to the city of San Antonio. And I can't just go to the website and access it. I have to be given a username. and
All right,
login.
so my answer to my question, it's not proprietary. Is that correct? Yes or no?
I don't know the answer to it, but perhaps the court, if I can assist the court. When I talked about the URL and the bookmarks, you cannot see that unless you're logged into.
Well, no. I want everybody to stay focused because I have specific questions and then I will allow everyone, if you wish, to add more to your argument. So my first question, is that software proprietary? Yes or no? Does anyone know?
I don't know the answer to that. I don't want to misrepresent to the court.
All right. And is it correct that this information was given to the defense about the software in February or March? Does anybody dispute that it was in February and March?
I'm not sure of the month, but I believe it was later.
All right. And then, Mr. Cifuentes, are you the only attorney who is representing Mr. Alejandro?
Mario Del Prado is.
Okay. Now, then my next question is, with regards to the transcripts that you're speaking of. So it appears from the court's math that those transcripts, they had a chance November, December, January, February, March, April, May, June, July, and August. So that's 10 months for the transcripts. Now, with regards to discovery in this case, they're saying that there's some data that's missing from discovery. Is there data missing?
Yes.
All right.
We do not have the bookmarks, the comments from evidence.com. And there's no way that I can get those without being granted access with the username and login.
All right. So this is again about the software, correct? That everyone knew about the password being needed, maybe February or March. I will give you all even April. So let's say the state is saying that they informed the defense February or March. And you think it's later than that. Let's say it's April. We have May, we have June, we have July, and we have over 3 months to get that. And then you all, correct me if I'm wrong, you all signed an acknowledgement of discovery on May 30th, 2024. That's what the court has in its file. Everybody signed that. And that's after the court had discovery hearings on this case since January. And you all signed off on it.
Judge,
Yes. Oh, and here's the thing, defense, I'm just asking these questions. Each one of you will get a chance to do your argument. And if you want to add to what a previous defense counsel has said, you'll be able to do that. Yes, Mr. Cervantes. Yes.
The court astutely asked if Mario was my co-counsel.
Yes.
I can see that, but I was not present and available on May 30th when that knowledge was signed.
All right. And let me ask you this, how long has Mario Del Prado been practicing? Is it beyond 30 years?
I believe, but
Okay.
I understand the court's view of having co-counsel, but had I been involved, I believe I would have noticed that.
Okay.
And I apologize that I wasn't. It was unavoidable. Nevertheless, it's our assertion that the bookmarks and the comments are great in nature. And they're constructively in the possession of the state. And the state had a duty to turn them over. And my experience with the city is that anytime anything is requested from the city, Jim Cobb files a motion to quash or whatever.
Mhm.
And it's our assertion that the state should have obtained all of the Brady information since it's in the possession of the state. And the prosecution guide, there's 21 minutes of details that are wholly ignored. And we would be able to cross-examine the state witnesses that presented the affidavits and experts by showing that they did not even look at the body worn cameras during a certain time frame.
Okay,
And so we believe that if we're not provided that information, that our defense would be impaired, our constitutional rights would be impaired, and due process and right of confrontation.
all right, state. With regards to this information that they're saying that they don't have that Mr. Cobb has? This is after everyone has signed the acknowledgement of discovery that had been going on for over a year. So does Mr. Cobb have this information? Yes or no?
Towards the court's question, I don't believe that Mr. Cobb personally has.
Oh, please be seated. Yes.
I don't believe that Mr. Cobb has it personally, that it would be contained within the section of SAPD that runs and manages the Axon system. I know that I do not have anything that the state had that acquired in response to the requests initiated by the defense that we received, we turned over to them. It is not in the possession of the district attorney's office. The specifics from an exhibit that is part of what came out of the Axon documentation, and I can acknowledge the referred to URL, the activity. The state does not have that specific in the format listed here. And I've never had that experience of interacting with it. I have not had Mr. Cifuentes's background.
Well, where's the video clip? They're saying they don't have the video clip.
I am referring to, I assume he gave the court a copy of the same page. It is
Yes.
begins with item number 35 through 54, and he has highlighted item 52, a URL clip. And I'm saying this, the district attorney does not have in our possession.
Who has it?
I'm going to assume, and that could be a problem. I haven't focused on this. It may be there. I have not talked to.
All right, if it needs to be turned over to the defense no later than tomorrow. Next.
Your Honor, this is just one clip on one body camera.
All right, so here's the problem that y'all can remain seated. This is the problem that I don't think anyone is getting here. We have been on discovery for over a year. Everybody signed an acknowledgement of discovery saying they had received everything. So the court is going on the basis that you all have received everything. That's what everybody signed. So whatever they're saying they have not received now, even though they signed the acknowledgement of discovery saying that they received it, you all need to confer off docket to make sure that they get that.
May I address the court?
Yes.
So I understand what the court's saying. And I'll confess to a judgment error, but I'd like to explain what the judgment error is. So the court may understand where I'm coming from, and maybe the result will be the same, but what I believe is that Mr. Harris intended to provide everything that I requested, but I think that he may not have understood that there were documents or items that were cloud-based that had to be downloaded and printed out. I think he may not have understood that.
All right, I don't think.
I believe that when he told me that he was going to provide the Axon information, that it would include that. There's 3 sets of information that I had asked for, and I believe, I hope my motion made clear what I was asking for. But it's the 3rd area that was not produced, and apparently there was miscommunication between, or misunderstanding between Mr. Harris and myself. And I believed when he said that it was forthcoming, that forthcoming meant all three areas.
All right, so
And-
here's,
And I did not, and to apologize to the court,
yes,
I did not look in June when it was produced, whether in fact it include the third area. And I hope the court understands the reasons why I did not look in June.
all right. So this is what the court is understanding. The court is understanding that this case has been on discovery for over a year. All parties signed an acknowledgement of discovery on May 30th, 2024, saying that they had everything. So with regards to now people saying, I don't have this, I don't have that, and it was listed in the acknowledgement of discovery that you had it, you all need to confer off docket for that. Does everybody understand what the court is saying? All right,
Well, I do have a question here.
yes,
I hope the court understands the third area.
oh, please be seated. It makes it difficult for the court reporter to hear when everybody stands.
Yes, I hope the court understands the third area that's missing. And I understand you want us to confer about that third area. But if we don't get that, the bookmarks in the comments, would the court be receptive to another request for relief from the failure to produce?
Oh, well, here's the thing. If I deny the motions for continuance, then we will cross those bridges when we get to those bridges. But what I'm telling everybody is that when you sign an acknowledgement of discovery, it means that you are saying you have received the discovery. And I will tell you, the discovery acknowledgement says, e-discovery version acknowledgement. The parties hereto acknowledge the information has been disclosed pursuant to the district attorney's open file policy in hard copy form, as well as through e-discovery in the latest document versions identified as version 29 May 2024. And then there's, of course, the ongoing obligation to disclose. That was signed by all parties on May 30th. And the defense attorney who signed it in this case was Mario Del Prado, who you said is your co-counsel. So by signing that, everybody acknowledged that they've received it through e-discovery or hard copy.
Your Honor, I believe that, and I want to make the record clear.
Yes.
I believe that the state did provide what was in their possession on that date.
Mhm.
The Axon audit trails were provided afterwards, and they were not in the possession of the state on May 29th. They were provided on June 6th, and we have an email from Mr. Harris where he, I believe, attached 42 PDFs of the audit trail on June 6th.
Mhm.
And so as part of the ongoing duty to disclose, I believe he was making efforts to do so. But while he was making efforts to do so, he only disclosed the second tier of what we were requesting. And we've never gotten the third tier. I just want to make clear that that I believe it was truthful that he provided everything that was in his possession at the time, because the audit trail that he emailed to us on June 6th, I believe, was printed out on June 2024 by Detective Soto. So it hadn't even been created on the date that the acknowledgement was signed.
Mhm.
That's what I want to be clear on.
All right, thank you. All right, next defense counsel.
I'm Judge Tom Nisbet on behalf of Alfred Flores. I'll pick up, I guess, first with the discovery issue, then transition into our expert issue. We joined in Mr. Fuentes and Salazar Alejandro's arguments, adopted and incorporated all of them. And I would like to address the court's comments on the signing of the discovery acknowledgement.
Yes.
That signature on that document memorialized that we had what Mr. Harris had given from his file. I would represent to the court as an officer of the court, his file was in disarray, that he had made comments that it was duplicate, triplicate, and that it was a mess, and that he was not satisfied with what he was given by TD. I would say to the court that the ongoing duty of the state to investigate and discover additional evidence goes beyond whatever is in that index, and that we were given multiple iterations of that index, each time increasing in document and exhibit number by the hundreds.
So what have you guys been doing since January? Because this discovery has been going on since January.
I can answer that question.
Yes.
There are,
And also, what have you guys been doing since May? Because everybody signed the acknowledgement of discovery in May.
the signing of that discovery acknowledgement says, what Mr. Harris says is on that index, we were given. And we all spent a considerable amount of due diligence verifying that what Mr. Harris said was on that index is in fact in the Verapik jumble. The arguments that were made, and so I guess to then answer the follow-up court's question, reviewing and going through the evidence, trying to synchronize, harmonize, analyze, further investigate, because there is a ton of it in this case. We all have multiple terabyte drives for this case. I think every counselor in this case would acknowledge that this is an incredibly evidence voluminous case, more so than maybe anybody else has seen in their whole career. And there's a lot more experienced jurists here than me.
Not me.
In the era of body cameras and technology and everything like that, it is very, very evidence heavy. So you can't watch my videos at the same time, right, Judge? There's an incredible amount of due diligence that goes into it while simultaneously trying to run a law practice. With that being said, I am not casting aspersions. I am just going to express my sincere worry about the complete package of the evidence in this case. Although, yes, we signed that what was on that index is in our possession, we come across things that are not in that index that are very important to this case. And in my motion, I gave you a prime example.
All right, and do you have co-counsel on your case as well?
I do, it's David Christian, he is back there, Judge.
Hello.
Officer Andrew Chernak was an on-scene officer who was part of the breach plan, who was pre-trialed by the state, who testified under oath in the grand jury, and appears to be central to at least the former prosecutor Darrell Harris's theory of the case. We received his pretrial notes, which is maybe in the ballpark of like 120 or 150 words total. But then he went into the grand jury and testified for a considerable amount of time. His exposure at the scene was a considerable amount of time, observations, reports, etc. We learned recently that Andrew Chernak had been emergency detained around 2021. He was taken out of active duty. There was an arrest in Hondo. There was a firearm. There was alcoholic allegations, all kinds of things that would be very interesting and ripe for cross-examination, credibility reasons, for evaluating Andrew Chernak and why he might be turning his testimony in this case.
All right, are you saying you don't have that information?
100% I am, nor was it presented to the
State,
grand
give him
jury.
that information, and you're to give him that information no later than Friday if it's in your possession.
But it's a touchstone moment, Judge, just like us learning that Officer Ramos and Officer Salinas had to sit out for medical reasons after this because they felt so bad about what happened. There's documentation to that. There's medical follow-up to that. But the touchstone of what I'm getting at is the duty to investigate goes into all of those individual things. And I think due to the volume and the disorganization on this case, I do not know if that duty to investigate has been fulfilled. And examples of those are what are coming out of Mr. Cifuentes and my mouths right now. And it is cause for concern. It's grounds for a mistrial. If Andrew Chernak was sitting on that witness stand right there, and it's just it's a good faith due diligence argument I'm making to the court that despite signing that discovery acknowledgement, that there's things that weren't in that index and there's things that weren't given to us. And we are feeling that relying on well, it's really disorganized, but I'm pretty sure I gave you everything. That's a very risky proposition when these gentlemen are going to go on trial for their lives. It's a very, very risky proposition. And I know the court is frustrated at the amount of
No,
discoveries.
I'm not frustrated.
Okay, then,
I'm just stating facts.
okay.
You all have been here since January on discovery.
Okay.
So no frustration on the court's part. I'm just stating facts.
Well, that's my argument, Judge, when it comes to discovery. Additionally, or in the alternative, we have filed our original motion for continuance and a supplementary towards the court because maybe counsel wasn't detailed enough in our argument the first time. We didn't do a real good job of explaining to the court exactly the bullet points of 2906 and how they apply in the present case. So we duly filed a supplemental motion for the court's consideration on the issue of the expert. So on behalf of Alfred Flores, I'll go into our expert, who is Mark D. Sawa, a nationally recognized use of force specialist. We've attached an exhibit to our motion, which is his resume. Judge, he would be and is very much a material witness in this case. Every part of his expert opinion and testimony will go to the central issues of the case: tactics, police use of force, self-defense, deadly force during an arrest, police investigations, thoroughness, protocol, and the list goes on. He has spent considerable amount of time and hours reviewing the material and conferring with counsel. We have been in good communication with him at all times over the period of many months as we exercise due diligence in both communicating and keeping him up to date. He is unavailable for the court's present trial settings, and I elaborated on that in my motion. He has to testify in another trial, state of Texas v. Curtis Taylor. He has pre-booked travel and professional obligations that are cause for his unavailability. We have not made him absent by consent or our procurement judge.
And where in Texas will he be? Because you said state of Texas versus, so what part of Texas will he be testifying in?
I can find that out, Judge, and I do know that a lot of his travel is taking him to the Northeast for seminars and speaking engagements and things like that. But I can find out further where the state of Texas versus Curtis Taylor is. Judge, it's our opinion and position on Mr. Sawa that he is central to a fair trial for Alfred Flores and all defendants at this point, as we are joined, that he is a material witness in all things. Now, if we were denied the use of Mark throughout the pendency of the trial, then Alfred and his co-defendants, I think, would irreparably suffer harm. Mr. Sawa, as an expert in law enforcement, is able to and plans to sit and listen to every law enforcement witness that the state is going to call. So pretty much everybody in this case is going to be a cop, to put it simply. So the choices they made, their knowledge of the case, self-defense issues, search and seizure issues, every single witness will give opinions or express knowledge and their implementation of tactics in the case. And that needs to be listened to by an expert witness who's excluded or is not excluded from the courtroom during testimony, who will listen and audit and then offer opinions as to each and every one of the state's witnesses, the state's expert, before he then gives his opinion and analysis independent of all those things. So to play a whack-a-mole of get this man in here for one day for testimony, it deprives Alfred and the other co-defendants and co-counsels the full use of that expert, which is central to the defense. And that is, he needs to hear every bit of evidence in the cause in order to be fully effective. And what we're saying is.
And you're saying he needs to hear everything to be fully effective in
Yes.
his testimony?
Yes.
Okay, I understand. Thank you.
Judge. And I apologize to the court. I didn't do a good job of explaining this at the last hearing or really articulating it in my prior motion, but I wanted to lay it out for the court because there's risk. And I say this very delicately and very lightly, but We cited some case law in our opinion. I think co-counsel cited some similar case law, and that is if that expert witness in his materiality and his testimony of both listening to all those other witnesses as well as his own analysis and opinion, which is a two-part of his testimony.
Yes.
If our client is not afforded that material testimony at trial, it can be reversible error.
All right, so here's the thing, when people want to throw out terms like reversible error, those already are like buzzwords. Judge, you're setting yourself up for reversible error. But here's the thing I want all the parties to understand about my rulings. I listen to what parties have to say. I make my rulings based upon the law, and whatever is within my discretion is within my discretion. I don't make my rulings based upon if this were to go up on appeal, what would the Fourth Court do? What would the Texas Supreme Court do? That is not in my purview. And so when people throw out terms like it's reversible error, or if it's harmful, thank you for throwing that out. That's what I will say.
It was with great trepidation, Judge.
Yes, but that doesn't, so that the state will know and that parties will know what the Court of Appeals or the Fourth Court may or may not do does not play a role in my listening to what the evidence is that you are presenting or listening to your arguments. The role that the Fourth Court plays for me is what was their decision on this case and what are the legal rules? That's it. What is the law? Did they interpret the law some sort of different way? What is it? That's all I'm focusing on, and hearing the evidence or the argument that you all presenting and reading your case law. But what other people may or may not do with my rulings, that's not what I consider.
Yes, sir.
All right.
Then let me move on to the next argument that I have.
Yes.
And that is the court had concern at the prior hearing that Mr. Sawa had not been issued a subpoena on behalf of Alpha Flores by counsel. And that is true. But it's our position that a retained expert need not be subpoenaed. And we did not subpoena. What I would like to just reiterate for the court and further develop for the court
Yes.
is we retained by contract Mr. Sawa.
On what date?
Ooh. I could tell you, but it's many, many months ago.
All right.
Is that good enough for now?
Yes.
Okay, it was a long time ago, Judge. We retained Mr. Sawa and providing him the discovery and the evidence and everything like that. We had noticed the state and filed that. I believe that's my first exhibit attached to my motion, our notice of designation of expert. It is marked and his necessary contact information. And then under the case law, that is sufficient for an expert. And I guess I would just make an equity argument to add on to that. Think about if you could subpoena any expert witness out in the world and force them to come in and compel them to testify, then the world of compensating experts would be overrun, right? We could just subpoena them and not have to pay the check. So it's our position that in line with the Fourth Court case we cited in our motion, the steps that we, in due diligence and good faith, we're supposed to take to notice our expert.
And counsel, surely no one would subpoena an expert who had not reviewed their case.
Well, I guess we find it when they got there, right? We followed all the steps necessary according to the case law and fulfilling our hurdles and our obligations under 2906. And so, Judge, we would ask that we be granted continuance under 2906. We strenuously ask that we would be granted a continuance under 2906 as we have fulfilled and developed each prong of 2906 in compliance with the case law that we cited from the Fourth Court, and that it would be an appropriate remedy in this case of tremendous magnitude where these men are facing an allegation of murder or ag assault by public servant, which are both 5 to 99 or life. It is a very important moment to these men, and I think the family as well. It's an important moment to everybody, and I would be reticent if I didn't give the court a little bit of drama and say we don't want it to go poorly for anyone. We want it to be done the right way. I could speak as an officer of the court that the state shares in these concerns on the unavailability of experts. I think they in good faith acknowledged that at the prior hearing. And I think they're being forthright as officers of the court in acknowledging that, gives everybody concerns. But I think it was a shortcoming of counsel that it was not explained thoroughly or properly to the judge at the prior hearing. So I'm here now urging it to the court that under 2906, it would be appropriate. And secondarily, under 2902, by agreement, there is an additionally or any alternative grounds for granting the continuance should the judge wish to acknowledge or entertain that code provision as well. And then just a short factual update. I think Mr. Goss is watching us right now in real time in a hospital bed with his dear wife, Marissa Stewart, who is getting induced to give birth to their daughter today. So I think Patrick's going to speak to that, but I know my heart is with them as the court knows, dear friends of mine. So with that, Judge, I rest and thank you.
All right,
I failed to mark these exhibits. I'd like to mark them and introduce them to
Sure.
the record. And the first one is one sheet of one sheet of the Axon printout, just one officer. But the PD said 451. What was best?
okay. You can, I would say since this is a hearing, you can label it as defense P1 for pretrial hearing.
And then general manual, we can have it as P2
Yes.
and any objection?
No objection.
We would offer defense P1 and defense P2.
All right, defense P1 and P2 are admitted without objection. All right, and Attorney Ballantyne?
Yes, Patrick Ballantyne for Nathaniel Villalobos, Judge. I'm not going to reiterate all the arguments of my able counsel for my co-defendants here, but I will just speak to the things specific to our motion and supplement where appropriate, and hopefully that'll be the most efficient way to do this. So, Your Honor, we filed a renewed motion yesterday, which I have provided a copy to the court and the state. And in that motion, we advanced the same ground as we did in our first motion, that being the unavailability of our expert witness, Dr. Ron Martinelli. His qualifications and the substance of his testimony are detailed in the motion, Your Honor, but he would be speaking to the use of force, the reasonableness of the use of force by Defendant Villalobos. He would rebut the state's noticed expert witness who claims that force exercise was not reasonable, and he would impeach and critique the state's or the police's investigation of this case. Your Honor, he would also be providing advice to counsel throughout the course of the trial with regards to how to respond to the various witnesses and other evidence that the state may provide. One thing I did add to this renewed motion are a couple cases which Your Honor speaks to her discretion, which I think is, I think you're right on there. And the parameters of a trial court's discretion in this particular circumstance and considering this issue, they aren't extremely well defined by case law because there's just not a lot of cases that go up on this particular point. But there is a case from the Fourth Court of Appeals, and that's Rodriguez Cruz v. State. And for the record, that citation is 590 Southwest 3rd, 29. That's the San Antonio Court of Appeals in 2019. And Your Honor, that case, I would encourage Your Honor to consult that if you haven't already, because it does provide some guidance to the parameters of your discretion in this circumstance. Additionally, it does speak to, it does by omission speaks to whether a subpoena is required for an expert witness. In that case, there was no mention of a subpoena. The Court of Appeals did not factor that into their analysis. They didn't say, well, you didn't subpoena the witness, therefore this claim would be waived. it highlights or emphasizes that what the focus of the analysis on that prong is, did the defense exercise reasonable diligence in securing the attendance of the witness to testify? And in that case, retaining the expert and calling him to testify at trial was sufficient to show the exercise of that diligence. Moving along to the discovery issue, I'm not going to reiterate what my co-counsel has said. I think he said it much more ably than I can and with much a greater depth of knowledge than I have on it. I would note for the court that the discovery acknowledgement that was executed by all of the parties is really that it's an acknowledgement of what has been provided. Of course, the defense cannot affirm that the state's discovery obligation is complete because we are on the other side of the veil of ignorance in that scenario. We don't know what we don't have. And so we do acknowledge that we were provided the things that were noted in that discovery log that was attached to the discovery acknowledgement. However, we would disagree that if it's suggested at all, that was an acknowledgement that the discovery was complete in this case, because of course the state has that ongoing duty to provide discovery of all sorts. And Your Honor, finally moving on to a new ground in this motion for continuance, and that's what Mr. Nisbet alluded to, the birth of the child of my co-counsel, Mr. Jason Goss. I didn't want to be pestering Jason on this day, but he did inform me last night that his wife's labor was going to be induced this morning, and that the child was expected to be delivered today. And as such, as he has declared prior to this, and for some months now, he will be engaging his family medical leave act rights and taking time off to both care for his toddler age child and assist his wife in the care of their newborn child. So congratulations to them. But Your Honor, that would make Mr. Goss unavailable during the presently scheduled trial date. And before Your Honor rightly asked me, do you have other counsel in your firm? We do, of course. But Mr. Goss is our trial specialist. I'm no trial attorney. I do all the motions work. I do all the research. I do the appeals and things like that. But Mr. Goss is actually the person we want standing before a jury. He's the person that Mr. Villalobos wants standing before a jury and making those arguments and making the cross-examinations during trial. Because he will not be available, we're positing that as another reason to the court why a continuance of this trial should be granted.
Well, and of course, then the granting of severance or not is also within the court's discretion. So maybe if he can't be here, then maybe you should be severed out from trying the case with the co-defendants.
That's a proposition I'll have to confer with Mr. Goss on.
All right. All right. Is there anything else from either side? Any more arguments? All right, defense, your motion for continuances are denied. We're doing jury selection on the 20th. I am aware, and I heard your argument, and I internalized your arguments with regards to your experts needing to hear testimony as they're excluded from the rule. As you all know, the court live streams, so they will be able to watch all of the testimony because it will be live streamed and they can watch that at their leisure. And with regards to experts coming to testify, the court will allow them to testify by Zoom if needed. All right, everyone. Thank you.
And Your Honor, can I clarification? What did you ask the state to produce and by what dates?
If there are some outstanding documents that are needed that you're saying that they have, for example, I believe you stated that there was some grand jury testimony. Am I correct? And you're saying you don't have that? Someone said they didn't have that?
There was information about an emergency detention and
Alright.
also the information in the URLs that were listed in the audit trails. We don't have any clips that are referenced in the URLs.
All right,
in
and
the audit
that's,
trails.
and then I believe you also said there was something that Jim Cobb would be in possession of. Am I correct?
Well, we would like, can we bring an order to the court requesting that we be given a login and password to evidence.com for this file? I think that's the easiest way to do that. Can we bring an order?
All right, well, let's address first things first. With regards to that emergency detention. I believe that may be covered by HIPAA. So y'all will have to breach HIPAA laws with regards to that. With regards to the last item that the defense counsel is asking for, State, are you able to provide that?
The last item being the hyperlink
Yes.
video is enclosed. I will make inquiries with the department and their Axon people.
All right, y'all need to be back here by no later than 1:30
So.
with that information.
I understand what the court's asking, but we would prefer to have a login. We prefer to have a username and login for these sets of videos.
All right, so State, you ought to be back here at 1:30 to have some update to the court on that information. Everybody be back here at 1:30. Is there anything else?
No.
All right, thank you.